Listen, if you own a rental property anywhere in Massachusetts, you need to stop what you're doing, because what is happening as of today is that the state is attempting to move a law forward that lets the tenants of your rental property basically buy the building right from underneath you when you go to sell it. Not buy it in the open market or something like that, like everybody else, but it allows them to move to the front of the line ahead of any legitimate buyer who's already made an offer. That's what we're going to talk about today. And specifically, this amendment, they have tried to get this passed for like the last decade. It keeps on popping up and popping up, but this time was a lot different. This just happened yesterday. This time, what they did is that they snuck it into an economic development bond bill. It was one of, I believe, 29 other amendments. And what they did here is that they bundled them all together and they waved them through with a single vote. And the crazy thing about this is the time that they had to review the bundle that this specific amendment was hiding in was 30 minutes. 30 minutes. And look, I don't understand how the hell some of these people get 30 minutes to vote on a bill that actually get to the point where they even understand the bill in the first place. I think it is actually impossible to do that, but that's by design. That could be another video. But anyway, I'll do the work that they didn't want to do. I'm going to walk you through exactly what this law does, and then I'll also talk about some of the few other places that already tried to run this experiment, and at the same time, all of those other places are running away from that experiment. Here's how it goes. The amendment adds a new Section 36 to Chapter 184. And on its own, meaning by itself, it does absolutely nothing, right? It just sits there dead until a city or town decides on some kind of vote to turn it on. So it could be your select board. It could be your city council. But once they flip that switch, and within 180 days of that switch being flipped, it is live in your town or city for that matter. And here's what that exact switch turns on. So if you own a rental in a town that does have this switch flipped and you decide to sell that property, before you could sell to anybody, your tenant gets the first crack at the property. A tenant group representing at least 51% of the occupied units gets what they call a right of first refusal. They can match a legitimate outside buyer's offer and take the place with those exact terms from the outside buyer. So theoretically, I think that this means that the tenant actually receives the offer from the outside buyer, meaning they get to see the terms of that offer, they know what the price is, and they can match it. Now, maybe on paper, that sounds like a potential win. That sounds like tenants, this is a pathway for tenants to become homeowners, right? But the part that actually matters is that the tenants don't have to buy it themselves. This is part of the machine that I'm going to talk about here. They could hand this property off, meaning the right to buy the property, to either a nonprofit or to a community development corporation, an affordable housing development, to a land trust, or to the city or town itself. That handoff is the engine of this entire thing. You need to remember that, because here's how an ordinary sale might play out. You have to notify, as a landlord, the town and or the city and every single tenant in that household that's living in your building in writing about the sale. Then the tenants get 15 days to make an opening offer. If they decide, you know what, fine, you sign a deal with an outside buyer, maybe you put it on the market or whatever, that would be the next phase of this. But it doesn't end there, because now you have to hand your tenants that signed contract and give them 30 more days to potentially try to match it. And if they do match it, they get up to 160 days to inspect the property, to finance the property, to appraise the property, and to close on the property. So if you add up all of these timelines, you have like 15 days, 30 days, and 160 days. That's like 6 months minimum where your sale of your rental property, your asset, is completely frozen while your tenant sits there holding a copy of exactly what your outside buyer offered that more than likely was going to close within 30 to 45 days. And that's just a normal sale, okay? It gets sharper if you're in any levels of trouble, meaning maybe it's a short sale or maybe it's a foreclosure. This is when the teeth come out. In those cases, the owner has to notify not just the tenants, but the town, the attorney general, and the state housing office. Then what happens is the attorney general enforces the entire thing. So a tenant who thinks they got shorted can take you to court under Chapter 93A. And if you do sell to somebody who isn't your tenant, you are filing a sworn affidavit at the Registry of Deeds swearing you followed every single step to a T as part of the process. This is, again, the machine. That's what they put in place with a 30-minute review. Okay? This is what they put into place. So you might be wondering, what does it cost? What is the cost of sale? And I don't even mean the money here. And again, I'm a realtor for over 12 years here. This is my wheelhouse. So you figure a normal deal in Massachusetts, especially if it's like a multifamily property, an investment property, usually they close within 30 to 45 days. If it's cash, it could be within a couple of weeks. Now, if you bolt on an additional 6 months and a right of first refusal onto the front of every one of those deals, it's a problem. There might be, a right way to help tenants here, but this is not the way. This is completely wrong. I think they should have consulted with people inside of the real estate industry to try to figure out a pathway forward. I'm not advocating for this. I'm just saying that you should consult with professionals that know what they're doing and not just mock something up, in your bedroom overnight. I think that they're flying too close to the sun here is what I'm trying to say. Because again, this isn't the first time they tried to introduce this. They just decided to sneak it in an economic development bill, like I said. Remember, the tenant doesn't have to close after that 160 days. They could literally tie up your property, and by that time, it could be the middle of damn winter. It's a huge problem. Who is going to try to spend 6 months working on a mortgage for this specific property that could be tied up for better part of a year? You see what I'm saying? And then you could really get into the weeds here. What about the rate? What about the rate lock? What about the rate lock extension? Who's paying for those? Are the landlords going to have to pay for a tenant's rate lock extension because they can't close in the time that the lender originally proposed? Do you see what I'm saying? This exact fight has already played out in multiple parts of the inside and outside of our country. And you could look none other than to San Francisco. Out there, sellers got hit with delays from 5 days up to 6+ months or more. And remember, who does that hurt the most? It's not the big institutions. It's the family settling an estate on a deadline, or it's the person trying to do a 1031 exchange, which, basically the IRS gives you a hard locked clock to try to reinvest that money without running the clock out so you could save some money on taxes. All of those things become compromised with an amendment like this. But here's the part where this entire pitch falls apart. They want to tell us that this protects tenants. This gives an opportunity to help tenants. And in one hand, it does, right? But who it disenfranchises the most are the mom and pops. There's a specific carve out in this bill. If you are a real person and you own 6 units or fewer in a specific town and you live in Massachusetts, you could potentially be exempt from this law or from this amendment, which sounds fair to people, that may not know a lot about what happens inside of this industry, right? Except that exemption only works if you hold the property in your own name. That's part one. The other problem here is that almost every single, and I've represented a lot of them, almost every single landlord in America gets told the exact same thing by either their attorney or their accountant, which is put your rentals in LLCs so a lawsuit can't come after your house, your savings, your asset. It's the single most common practice. It's the single most common piece of advice a small homeowner that owns units gets. So the second you take it, meaning you take your property from your name and put it into an LLC, that exemption is gone. Now you are inside of the machine. Also, if you own the property, but you live out of state, maybe you live in Florida full time, but you still have rentals inside of Massachusetts, that exemption is completely gone. So when they try to tell you that mom and pop is protected, it's not false, but the fact is that the majority of the most people that actually own these considered like mom and pop, rentals, they're in LLCs. That's a fact. And this isn't some fringe idea that nobody has vetted before. Even Governor Charlie Baker decided to veto this exact policy back in 2020. He said that it would significantly delay the sale of multifamily homes. So look at it this way. We had a sitting governor that looked at almost identical language and said no. And now they're trying to pass it anyway. Again, after a 30-minute review. And I'm willing to bet at least 90% of the people that voted inside of that room had no idea what they were voting on. It's almost impossible to review an economic development bill and then also bolt on all these other amendments inside of the bill itself. It's crazy to think that they could review it in 30 minutes. So now you need to think about who actually benefits from this. On a surface level, it looks like a pro-tenant amendment or a pro-tenant policy or bill. This is the emotional hook that they try to do. This is the emotional games that they try to play with the public. But when you check whether that is actually what happens or not, guess what it isn't. And we don't have to guess because, again, this has been tried and tested inside of other markets. Washington, D.C. has run this exact law since 1980, okay? So there is like 45 years of receipts. And you don't have to take my word for this. Just watch what the NBC4 investigators down in Washington found.
It felt like extortion. Like the whole thing felt really slimy.
High dollar payouts, homes held hostage. This is impacting sales and rental prices across the District of Columbia. And the News 4 I-Team has uncovered loopholes in an old D.C. law that is now being exploited for profit.
It basically gives renters the chance to buy their place first. But the News 4 I-Team found even when they don't want to or can't afford to buy, they can rake in big bucks by selling those rights.
That's not a tenant becoming an owner. That's a check that they get in their pocket to effectively go away. There's an entire cottage industry down there of people who know how to work the notice and they decide to play these games to try to make a profit. And down there, you barely had to be a tenant to pull it off because DC's laws never required you to be on the lease or to even pay rent. Now, you might be wondering how this works. How are these tenants getting payouts? Basically, the tenant ends up holding the right to convey the property. They get the ability to hold that asset and to pass that asset off. So if a developer wants that asset and the developer may end up be willing to pay more to be chosen by the tenant, guess what happens? The tenant in turn makes a profit. They basically turn the tenants into a wholesaler, which is absolutely insane. Now, I'm not entirely sure if Massachusetts has carved out some kind of language to, this anti-cash out clause is what I believe they called it in DC. I don't know if that language is actually in there. I don't believe that it is. If it isn't, it's something they need to look into because if the tenants aren't the ones that are actually buying these buildings and then they're basically acting as a wholesaler, it's a problem. Now, take a wild guess who is the biggest beneficiary of stuff like this. Because it's not the tenants. Oh, no, it's not the tenants. It's who is the right as their successor. That is who the biggest beneficiary is, which could be a developer, right? It could be a nonprofit. It could be, any of these big investment firms. That's who actually wins here because the tenant, again, gets to offload this asset to these people, okay? That's what is going on. So it's not the tenant who wins, it's still the developer. The tenant is just kind of like the key that opens the door, and then a much bigger player ends up walking through that door. And this isn't a loophole that somebody found, and it's not a bug. This is a feature of this type of legislation, and that's the truth. But the reality here is that the places that have lived with this the longest, they aren't expanding on it. What they are doing, though, is that they are actually backing away from parts of this process. If you look again at DC, right, which again is the place that this thing was like birthed or like invented or something, back in 2018, the DC Council pulled single-family homes, condos, and co-ops right out of the law. Because remember, sometimes people will own a home, they will own a condo, or they will own a co-op, and they'll use that as a potential rental property as they make another single family home, either within the same state or outside of the state, as their primary residence. So they eliminated those from the pipeline because people were abusing the process, and it was so bad that they had to do this. That's the way it goes. This is what is happening in Massachusetts. The governments that ran this the longest are the ones that are backing away. And here in Massachusetts, we're trying to adopt failed policies from other states. This isn't the first time something like this has happened, right? It's not the first time that this has happened. But the key here is that Massachusetts didn't even debate which side of the coin they want to be on. They just picked a side in less than 30 minutes. Like it's another heist is what it is. It's another heist with another paper trail right here in Massachusetts. And, you know, I'll be watching how this plays out and to see if this makes it even further throughout the process. Anyway, thanks for watching, guys. I'll see you on the next one. Bye-bye.